Public interest litigation. Yes, we can understand it step by step. Public interest litigation. First of all, do you know what is litigation? What is litigation? In common parlance, we use the word litigation to refer to some kind of legal action or some kind of legal proceedings that you initiate to protect your rights or to enforce your rights. What is litigation? Litigation means a kind of proceedings, legal proceedings in front of the court. Litigation refers to some kind of legal proceedings in front of the court in furtherance of some rights, some claims. Your rights or your interest has been violated by the action of an individual or institution by government. To enforce your rights, to enforce your claim or your interest, you initiate legal proceedings or proceedings mentioned under law in front of the court. Why? To seek justice. This is known as litigation. Clear? So litigation means proceedings in front of the court in pursuance of justice for the enforcement of rights, obligations, duties, etc. Clear? This is your litigation. What is interest? The word interest in legal parlance or language, interest means right. It means interest means some kind of right, some kind of claim that you enjoy by virtue of some kind of law. So there is a law. Under such law, you have been conferred with certain rights, and these rights are known as interest. In furtherance of this interest, you resort to legal action or legal proceedings. Point is clear? So therefore, interest means some kind of right, some kind of claim, some kind of right, some kind of, not on the basis of your subjective whims and fancy, some kind of right, some kind of claim as recognized under law. You are a worker in one of the factories recognized under law. So under industrial law, under commercial law, as a worker you enjoy certain rights. It means you have some interest, some rights recognized under industrial law or commercial law. And if such rights are violated or such rights are threatened, so in that case you can initiate legal proceedings to protect your rights. So litigation means some kind of proceedings in front of the court. Why? In pursuance of justice. And interest means some kind of right, some kind of claim recognized under some law or provisions of the Constitution, enjoyed by an individual or group of individuals. And public means you know very well. The word public refers to the collectivity of people. Public at large. So now bring all three words together. Public interest litigation. So what is the meaning of public interest litigation? Litigation, some kind of proceedings. So public interest litigation refers to a litigation or the proceedings in front of the court in pursuance of interest or rights not of an individual but the public at large, which is known as public interest litigation. So public interest litigation, unlike private interest litigation, is the one which refers to the legal proceedings, which legal proceedings in front of the court, which aims at protecting or promoting the interest or rights of public or a particular group or community or any sizable chunk of society. Okay. So why do we need public interest litigation? Because the reason being that there can be a group or community in our society. There can be a group or community in our society who enjoy certain rights under a particular law or under the provisions of the Constitution. But because of poverty, because of illiteracy, lack of education, lack of awareness, destitute, or one other kind of deprivation, you can say, that group or that community is not in a position to reach out to the court of law in furtherance of its interest or to protect its rights, which may have been violated or which may be threatened. So in that case, they can take resort to public interest litigation. So in that case, any public spirited person on behalf of that community can file petition in the court of law or can initiate legal proceedings in front of the court. Why? To protect the interest or rights of that group or community. This is known as public interest litigation. So in simple terms, public interest litigation is the litigation which aims at protecting the rights of the people at large, rights of any group or any community at large who, because of poverty, illiteracy, lack of awareness, are not in a position to protect their rights on their own. Clear? Private interest litigation, on the other hand, refers to litigation which aims at protecting or promoting private interest. So all litigations in a way can be categorized into two: private interest litigation and public interest litigation. Public interest litigation is the litigation which aims at protecting or enforcing the collective public interest. PIL or public interest litigation cannot be filed in Supreme Court or High Court in furtherance of private interest, because if it is made out or if the court comes to know, judges they come to know that in the name of public interest litigation, you, instead of protecting public interest, you are pursuing behind the curtain your private interest. So in that case, not only your petition will be rejected, but in extreme cases, court can pass strictures, court can also impose a huge fine on you. This is public interest litigation. Public interest litigation can be said to be one of the very important, you can say, innovation of the Supreme Court to bridge the gap between the authority of, stupendous authority of the higher judiciary on the one hand and the rights of the people, the plight of the people on the other. Former CJI P.N. Bhagwati is known as the father of public interest litigation in India. It was because of his extraordinary effort and initiative that public interest litigation was developed and it was evolved. So public interest litigation is one of the most important innovations of the Supreme Court in recent times, so as to create a possibility for the public spirited persons to reach out to the Supreme Court and High Court directly. For what? In furtherance of the interest of poor people, a group of people who, by reason of poverty, by reason of lack of education, lack of awareness, they are not capable of reaching out to the court on their own. They may not have resources, they may not have knowledge, they may not have required, institutional wherewithals to protect their rights and to move the Supreme Court and High Court. So on behalf of such person, on behalf of such people, a public interest litigation can be filed by any public spirited person. He is not supposed to be, it is not necessary that the petitioner must be the victim. It is not necessary that the petitioner's own interest should be involved. Normally what happens when you file petition in the court of law, what is the policy of the court? The court examines your locus standi, that who has filed the petition, what happened to you. So normally the rules of locus standi is found to be strict, that the court would not like any Tom, Dick and Harry, any person to come and to file petition on behalf of, any person with whom he or she is remotely connected. So the person, the aggrieved one, the one whose rights have been violated or threatened, that person only is allowed to come and to file petition, on his own or through his lawyer. Getting a point? But in case of public interest litigation, because the logic is there is a group of people and who are poor, who are poor, destitute, or for one reason they don't have resources to come on their own. So that's why in case of public interest litigation, the Supreme Court has diluted the rules of locus standi. It means it is not necessary that one of the victims should move the court, Supreme Court or High Court. Any person, public spirited person, on behalf of such group or community, that public spirited person may not be a part of that group or community, but he may have observed, their plight or their problems very closely. He may have collected all the facts and details, and then that person is allowed to file public interest litigation. So rules of locus standi has been diluted by the Supreme Court in the case of public interest litigation. So this has been done to ensure that wherever you have such people, such group or such community who for one or the reasons they are not in a position to reach out to the court on their own and their rights are threatened or their rights have been violated, so the matter could be taken to the court of law on their behalf by any public spirited person. This is the basic logic behind public interest litigation. So you can say it is one of the most important innovations of the Supreme Court in recent time, so as to democratize judiciary. Democratization of judiciary. Why I am saying so? It is about bringing judiciary, honorable judges of Supreme Court or High Court, to bring them more proximate to the realities of the society. Supreme Court, High Court judges, they enjoy ultimate authority. Supreme Court, judges of Supreme Court, the Supreme Court is the guardian of the Constitution. Supreme Court is the ultimate interpreter of the Constitution. Supreme Court is the last word for justice. But normally it was found that the stupendous authority of Supreme Court was not so much of relevance. It was not of so much of relevance for the Aam Aadmi and common people. Why? Because Aam Aadmi has armed problems, common problems. That problems may be very much excruciating in nature, but for one of the reason, the complex rules and procedures, so Supreme Court judges were not in a position to intervene in the day-to-day life of the people or to apply correctives or remedies to the problems or to the grievances or to their grievances. So therefore, public interest litigation has been designed. Public interest litigation has been designed as a tool which has facilitated the intervention of the judges of Supreme Court and High Court in the subject matters of interest of the common people in day-to-day life. So whether it is a matter related to triple talaq, the plight of Muslim women, or the issues related to transgender, or for that matter it is related to cleaning of Ganga or environmental protection, sound pollution, air pollution, etc. Or it may be a matter related to efficient enforcement of lockdown during corona crisis, something. So there are a number of issues which affect the day-to-day life of the people. But given the rules and procedures, such matter could hardly be taken up. Given the complex rules, procedures, protocol, etc., such matters could hardly be taken up. To the cognizance of the judges of the Supreme Court. But thanks to public interest litigation, now this gap has been breached. Thanks to public interest litigation, now the judges of Supreme Court or High Court, they have an opportunity to listen to the problems of Aam Aadmi on day-to-day basis. Wherever there is a gap in the performance of the government and expectations of the society, where there is a group, there is a community who are not capable of defending their rights. So in that case, public interest litigation can be an effective tool to be used by public spirited person to attract or to elicit the action of the higher judiciary, Supreme Court and High Court, to get the things done. This is the significance of public interest litigation. Rules and procedures pertaining to filing of public interest litigation have been deliberately diluted or simplified by the Supreme Court. It means even a postcard carrying that complaint, a postcard referring to some subject matter of collective interest involving some kind of violation of rights or threatened violation of fundamental legal rights. Even a postcard can be taken up as a petition by the Supreme Court, and rules of locus standi, as I discussed, has been diluted so that it is not necessary that a grieved person himself can file petition. No, any public spirited person can file PIL on behalf of a group or community facing many problems or facing some kind of violation of their rights. So PIL, you can say, has been devised to ensure that the justice reaches the doors of the poorest of the poor with due speed and economy. Why I am saying speed and economy? Because public interest litigation, the fees is not so much, is not very economical. It is not something which cannot be afforded. And secondly, why speed? Because PIL can be filed directly in the Supreme Court and High Court. You don't need to go through the process of appeal from lower courts to high court. Straight away you can move Supreme Court and High Court. It is totally at the discretion of the court to entertain your public interest litigation or not. Or in some cases, Supreme Court can ask the petitioner to move to High Court, depending on the gravity of the subject matter which has been brought to the notice of the court. Getting a point? This is public interest litigation. So it basically aims at bringing justice to the doors of the poorest of the poor with due speed and economy. Up to this point, it's clear. This is public interest litigation. Now, one by one, I am answering some questions. I am going to answer some questions so that there is a complete conceptual clarity. Now, the question is, who can file PIL? So, as I said, any public spirited person or any association or a group of such persons can file public interest litigation. The condition is very simple. What is that condition? That it should not involve private or individual interest. It should not involve any kind of oblique motive, some kind of political interest or motive of an individual or a group of individuals. If it is found that there is some kind of personal interest, if it is found that some personal interest is involved in public interest litigation, so in that case it can be rejected. As I said, in extreme situation, fine can be imposed by the court. It is totally at the discretion of the court. Now the next question is, when PIL is filed, does the court initiate action in each case? No. This is not necessary. You can file public interest litigation. Now it is totally at the discretion of the court. The court examines prima facie the genuineness of the petitioner, his interest, and the issues raised in the petition. So if you file public interest litigation, you raise a particular issue, you think that this is related to the collective interest of a particular group or community. But for one other reason, if the Supreme Court realizes that the subject matter in question does not deserve its merit and attention, and that matter should be taken up at the first instance by the executive government. So in that case, or if the petitioner himself is not a genuine person, it means he is some kind of busybody and he's just trying to seek cheap publicity. So if it is found that the intent of the petitioner is not intent is not bona fide, for that matter, subject matter which has been raised, that subject matter has been raised wrongfully because of lack of knowledge, lack of awareness. So in such cases, court can refuse to entertain public interest litigation. Getting a point? If the court finds that the petition is politically motivated or motivated by some kind of personal or commercial interest, if the petitioner is found to be, making an attempt to befool the judges of, the court,
एक कलेक्टर के कलेक्टर के काम होते हैं, जिसने कहा ना कि विकास के लिए कार्य करेंगे, उनकी नियामक गतिविधियां होंगी, कंट्रोल करेंगे, रेगुलेट करेंगे, फिर देखेंगे आपदा प्रबंधन वगैरह रिलेटेड उनकी एक्टिविटीज होती है, उनके एडजुडिकेटिव फंक्शंस होते हैं, हो सकते हैं क्या होते हैं, कई मामलों में वो वाद विवाद का निपटारा करेंगे, तो देखिए फिर वो एक ऑफिसर के रूप में भी रोल अदा करते हैं, तो उनकी बहुत सारी भूमिका होती है, लॉ एंड ऑर्डर, वेलफेयर, ये ये सारी चीजें इकट्ठा, तो आपके माइंड में अगर एक इमेज अगर है कि
off by the court, and accordingly the court issues notice to the respondents depending on the nature of subject matter. So once it has been done, after that petitioner is not at liberty to withdraw petition on his own. Why? Because public interest litigation is filed in furtherance of public interest, not the private interest. So once the petitioner has raised a question related to public interest, then it is not so much a matter of his personal choice to withdraw petition. Getting a point? So it means once the petition public interest litigation has been filed and it has been taken cognizance of by the Supreme Court, and accordingly Supreme Court has issued notice to the respondents, after that petitioner cannot withdraw his petition. In extreme situation, if the petitioner somehow succeeds in convincing the honorable judges why he is willing to withdraw, so in that case the petitioner can be substituted by another petitioner. In extreme situation, the court may allow the petitioner to withdraw. Okay, so petitioner can withdraw, but the subject matter once raised and the merit of the subject matter once realized by the court, that subject matter cannot be withdrawn. So if not this petitioner, the court can make some other person, court may ask some other person to step into the shoes of petitioner, and then the matter will be taken up. But petitioner is not at liberty to withdraw petition as per his whims and fancy. In a private interest matter, court normally permits the petitioner to withdraw, but not in public interest matter. Clear? Then there is a question: what is the time frame in which a PIL may be decided? Simple. There is no time frame fixed for settlement of any public interest litigation, but in general public interest litigation is given priority by the court depending on the subject matter or the gravity of the subject matter in question. What is clear? So there is no time limit or there is no time frame within which a public interest litigation has to be settled. It all depends on the nature of subject matter, and accordingly the court can take up certain matters on the basis of priority. Clear? Next is question: is there any prescribed form for making a PIL? No, there is no prescribed form for making a PIL. Even a letter or a postcard, as I said, can be accepted by the court as PIL if there is some kind of merit in the subject matter which has been raised. However, normally public interest litigation, this petition has to be in the usual form in which other petitions are framed. So there is no specific guidelines issued by the court that PIL has to be filed in a particular way. Even a postcard or a letter can be turned into or can be accepted as a petition. But normally for PIL, the petition is filed in the same way the other petitions are filed. So there is nothing special about it. Then who should be made respondents in PIL? This is the question. Who should be made respondents in PIL? It depends on the nature of subject matter. Those in respect of whom or against whom allegations are made, and from whom relief is sought. All such agencies can be made respondents. Suppose through your public interest litigation, you have filed a public interest litigation raising a question related to air pollution. So if you raise a question pertaining to air pollution, so court can make all those parties respondents, in this case, who are or who have been contributing, to the case of air pollution, who have been contributing to this problem, who contribute to this problem, and those who are supposed to provide remedy but they have failed to do so. So court can make a state transport corporation or state pollution board or the state government, respondents in such case. Are you getting a point? So all such parties are to be made respondents, who are directly or indirectly associated with that. In what language PIL can be made? Court language is English. Generally it is preferred. You can file public interest litigation in other languages as well, but it is generally preferred. If the court prefers English as a language in Supreme Court or High Court, English language is preferred. So PIL petitions should preferably be worded in English language. Then before which courts can PIL be moved? Before the High Courts and before the Supreme Court. Court. You should know PIL can be filed before the Supreme Court and High Courts only. This is for higher judiciary. Points clear? You can file public interest litigation before the Supreme Court if it involves violation, infringement or threatened violation of fundamental rights. But you can file public interest litigation in high courts in all such cases which involve violation of fundamental rights as well as legal rights. Are you getting a point? Just as the writ jurisdiction of high courts, writ jurisdiction of a high court is wider than Supreme Court. Similarly, the scope of jurisdiction of high court, in relation to public interest litigation is wider than Supreme Court. So High Court can entertain public interest litigation pertaining to violation of fundamental rights as well as legal rights of a group and community. Points clear? Then can a foreigner also file PIL? As I said earlier, that public interest litigation, to file public interest litigation, you are required to prove that you enjoy certain rights. You enjoy certain rights under a particular law. And because of the state action or inaction, your rights have been infringed or they are threatened to be infringed, which you enjoy under a law. So in that case, and it is related to a particular group or community, and then such group or community is not in a position to protect its rights on its own. So in that case, PIL can be filed. So all such conditions are applicable to foreigners as well. Why? Because foreigners in our country, if you see fundamental rights in our constitution and certain statutory rights, some laws and the constitutional provisions, even foreigners enjoy certain rights under Indian constitution under certain laws. If a foreigner, if it is found that the rights of a particular group of foreigners, rights are threatened, there is a violation of rights or there is a threatened violation of such rights being enjoyed by foreigners under a particular law or provision of the constitution, there must be a group of foreigners, and such group of foreigners, for whatever the reason, they are not in a position to move court of law on their own. So in that case, PIL, public interest litigation on behalf of such group of foreigners can be filed in the Supreme Court or High Court. I repeat, there is a group of foreigners. Foreigners, they enjoy certain rights under any law of the parliament, or for that matter under provisions of the constitution. They enjoy certain legal rights or statutory rights or constitutional rights, okay? And their rights are threatened. In that case, and then such group is such that it cannot defend its rights on its own. So in that case, public interest litigation can be filed by any public spirited person or any one of the foreigners on behalf of such group or community. So your answer is like even a foreigner can file a PIL. Next is, how many PILs can an individual or a group of individuals or an association of public spirited persons file in a year? There is no limit or there is no quota laid down by the court for this purpose, that an individual or a group of individuals or an institution can file only 4 or 5 PILs in a year. There is nothing like that. Acceptance of public interest litigation depends not on the quantity or number of PILs, it depends on the quality or the substance of the question being raised in the PIL. Are you getting a point? Quantity is not important, quality is important. You can file 5 or 7 PILs within few months and it can be accepted by the court, provided that every PIL raises some question which is of larger interest of the society, and questions are very relevant and very much substantive in nature. If such questions are properly addressed, it will certainly bring a qualitative change in the life of the people. So in that case, even 10 public PILs can be entertained by the court, filed by the same person or institution. So what I mean to say, it is not the quantity, it is the quality which is important. Then does the court pay cost to the PIL petitioners if he succeeds? No. Answer is no. if you have filed public interest litigation and you claim that because you are fighting not for your individual interest, you are fighting for the larger interest of any group or community, so therefore the legal cost should be borne not by you, it should be borne by the government. So this kind of claim cannot be entertained. Why? What is the established principle? That a public spirited person, he files PIL, public interest litigation, out of his own, voluntarily he files PIL. Why? To protect the interest of a particular group or community. So the fact that you are serving the interest of poor people or a particular group or community, it in itself is a source of motivation. So no money is required to be paid for that. So generally courts, we have not seen that the courts can provide for any compensation to the petitioner. But in some cases, if you succeed in convincing the court of law that you have incurred huge amount of expenditure and this has been done in the furtherance of the interest of the society, so in some cases, if the court is convinced, then the court can ask one of the respondents who has been found to be on a sticky wicket to pay compensation for the same. So your cost can be compensated for by the one who was made respondent and was found guilty, was found deficient in action. मेरी बात समझे? मतलब पॉल्यूशन का मामला था, तुमने PIL फाइल किया, तो जिसने बहुत ज़्यादा कंट्रीब्यूट किया पॉल्यूशन में, ठीक है, कोर्ट उस एजेंसी को कह सकती है कि आप इनको कुछ पैसे दे दें, वो compensation या जो समझ में। But in general, courts are not under any obligation to provide for compensation of the cost that you have incurred while filing public interest litigation. Public service in itself is a remuneration. So why are you seeking remuneration from the court? Clear? So this is all about public interest litigations. Clear? And if you ask me what are the recent cases of public interest litigation, there are many cases. Every now and then, every second day, you can see a new PIL has been, a public interest litigation has been filed. If you are simply alert and vigilant, and if you read newspapers regularly, every second day you will come across, you'll see some kind of public interest litigation, filed by some public interest. But generally, non-governmental organizations, voluntary agencies, and research and development groups, they have availed of this benefit more than individuals. So there has been so recently, during COVID-19 crisis, which is still in progress, a petition of public interest litigation was filed in the month of April and May. Why? To give direction to the government for efficient enforcement of lockdown. Similarly, a PIL was filed in the Supreme Court seeking ban on consumption of meat, during the period of Corona crisis. Even issues as humble as this, public interest litigation can be filed. So several PILs have been filed in the past to protect the rights of women, whether it's the issues related to transgender or environmental issues related to, the triple talaq. So we have seen, on all the or some issues related to education. So on all such issues, we have seen number of public interest litigations have been filed, and interestingly, such PILs have led to very positive consequences. Petitioners have been able to elicit appropriate judicial intervention or action to apply correctives to the given situation. So public interest litigation has played a very important role in furtherance of the rights of poor and destitute, who otherwise could hardly pursue the case on their own. Points clear? But there is a negative side of the story as well, because there has been several instances wherein the petitioners have filed public interest litigation guided not so much by the spirit of public interest, but they have filed public interest litigation motivated by narrow political or economic or commercial interest. That's why it happened just a couple of years ago that the Supreme Court took a strong exception to this kind of tendency, and Supreme Court reprimanded some of the petitioners. Supreme Court came out with very harsh words, saying that some people have made public interest litigation a kind of business. Some lawyers have developed a business out of public interest litigation. So PIL was originally designed to serve the cause of the poorest of the poor, the weaker, the destitute, and those who are not capable of fighting for their rights on their own. But over a period of time, there has been a group of lawyers, who have made a kind of lucrative business out of public interest litigation. Behind the garb of PIL, public interest litigation, they very often pursue narrow political interest of one other parties, or sometimes they also pursue commercial interest. In the name of PIL, in the name of public interest, they pursue the commercial interest of one entity against the other. So court took strong exception to such tendencies, and we have seen in the recent years there have been several instances wherein the petitioner was reprimanded, wherein the petitioner was fined 1 lakh rupees. It has happened in several cases. What is clear? So finally, what I mean to say, that PIL too has some merits as well as demerits, like most of the things. So PIL, public interest litigation.